well. For our second speaker, I'd like to now invite on stage, and I apologize if I mispronounce his surname, Benoit Pasquier, Director of Legal Affairs, Asian Football Confederation, which is based here in Kuala Lumpur. But just a very brief introduction of Benoit. Prior to his present stint in the AFC, in 2011, he had actually joined the Legal Affairs Department of FIFA, and where he was appointed Deputy Secretary of the FIFA Disciplinary Committee and Ethics Committee, and where he was tasked with managing various disputes, disciplinary and ethics cases at FIFA, and where thereafter he has joined as Director of Legal Affairs of the Asian Football Confederation, or AFC, based here in Kuala Lumpur since October 2013, where he oversees actually the entire gamut of the legal affairs and the legal team here in AFC. So without any more words from me, Benoit to take us through his paper. Thank you.
Thank you for your... Good afternoon, everyone. It's a real pleasure to be back here in the KLIAW. I was no later than 2 weeks ago, we were here, the AFC, having a CAS hearing. I think it was one of the first CAS hearing here in Kuala Lumpur. We had a disciplinary case against a famous football player who was elected AFC Player of the Year last year. And unfortunately, he misbehaved during the final of the AFC Champions League last year, and we imposed a sanction of 8 matches on him, and he went all the way up to CAS, and we, of course, being in Kuala Lumpur, Malaysia, we asked CAS to have the hearing here at the KLIAW. The legal counsel of the player, being based in Spain, decided no, we want to have the hearing in Switzerland. And finally, we were able to convince CAS to have the hearing here, and fortunately, we won the case, so rest assured that we will come back to KLIAW as far as we win all the cases. Yes. Anyway, today I would like to speak about a famous case who makes the sports lawyer and CAS quite nervous. There is an ongoing case of a German speed skater ongoing in Germany. Her name is Perstein. She went all through the sporting channel from the disciplinary commission, from the speed skating union, went through CAS, even went through the Swiss Federal Tribunal, and she lost her case, but she wants to claim now damages. And for that she went to a German court. And that German court, on first instance, rejected her claim based on that the CAS award was final and binding, and therefore couldn't review the case. However, she went further. She appealed that case, and the higher regional court of Munich decided, quite surprisingly, that the court was competent to review that case, meaning putting into danger the CAS institution and the whole sporting resolution system. So, here are the facts of the case. Perstein, as I said, is a German woman speed skater, and she's actively in that world of elite sport since 2 decades. She's affiliated to the German Speed Skating Association, which is affiliated to the International Skating Union. This is the typical pyramid of sport. You have regional association, national, sometimes confederation, and then international organization. The International Skating Union decided to organize a championship in 2009, February 2009, and in order to be entitled to participate in that championship, all the athletes had to sign an admission form. This admission form referred to several clauses on the organization of the competition or the disciplinary issues, and referred all the dispute regarding disciplinary issue to CAS as a last instance. So she signed that admission for being able to participate in that championship. One day prior to the competition, the organization decided to collect sample of blood of every single athlete for doping control. Unfortunately for Miss Perstein, her blood sample was abnormal. I'm not going to go into detail, I'm not a doctor, but according to the analysis of the different anti-doping authorities, she was convicted or allegedly convicted of blood doping. Based on the results, the case was referred to the disciplinary commission of the International Skating Union, which decided to ban or suspend Ms. Perstein for 2 years for a prohibited method, by using a prohibited method. Of course, Ms. Perstein was unhappy with the outcome of that decision and decided to go to CAS. So she lodged an appeal in front of CAS, requested provisional measures to be able to participate in any competition in view of the Olympic Games in Vancouver 2010 in order to be able to qualify for that competition. CAS decided on the provisional measure that she would be only able to participate in training session, therefore non-official competition. Important thing is on 29 September, CAS issued an order of procedure. That's the usual form each party will receive with all the submission dates, hearing dates, advance of cost you have to provide, and so on. And all the parties have to sign that form and send it back to CAS. A hearing was held during 2 days in Switzerland in October 2009, where several witnesses, experts were called to be heard. And the CAS decided on November 2009 to dismiss the appeal and to upheld the decision passed by the disciplinary commission. To be noted in that case in front of CAS, she was represented by 2 lawyers. When CAS gave the notice of the composition of the panel, she didn't raise any objection in regards to the composition and constitution of that panel. She signed the order of procedure. I didn't challenge the jurisdiction of CAS. At the hearing, she did not raise any issue again in regards to the composition of the panel, because usually at the beginning of the hearing, the president of the panel will ask the parties if they have any objections to the composition of the panel. And at the end of the hearing, before the closure, she expressly acknowledged that her right to be heard was respected and that she was treated equally by the panel. Of course, she wasn't happy with the outcome of the CAS decision, and she went to the Swiss Federal Tribunal. In front of the Swiss Federal Tribunal, you can only lodge an appeal on limited grounds. Those are, you can refer to that your right to be heard was violated. You can refer to the lack of jurisdiction of CAS, that public policy was violated by CAS, that CAS went ultra petita, as we said, that CAS decided outside of its jurisdiction. And she, of course, contested or challenged the independence of CAS by saying that the list of arbitrator of CAS is decided by the ICAS. The ICAS is the International Council of Arbitration for Sport. It's a body composed of 20 members, and several members are 4 members are appointed by the different international federations, and to be noted, only 4 members out of those 20 members are appointed by the athletes. So 1/5 of the ICAS is appointed by the athletes. The Swiss Federal Tribunal, as usually does in CAS awards, rejected the appeal lodged by Ms. Perstein by saying that the independence and impartiality should have been raised as soon as the ground was known. Public hearing, you can in front of CAS you can request a public hearing only if the other party consent. So Perstein should have in front of CAS requested that the hearing should be public and asked the other party to consent. Swiss Federal Tribunal, of course, said no violation of the right to be heard because she contested that she was not able in her written submission to contest one opinion of an expert, because in front of CAS you have only one round of submissions, so you have the appeal and the response. You cannot lodge again a response to the response, so only one set of submissions. And again, no violation of public policy. Public policy are fundamental principle of law, like pacta sunt servanda, or the right to be heard is a procedural public policy requirement. So Swiss Federal Tribunal rejected the appeal. In 2010, Perstein again wrote a petition to set aside the Swiss Federal Tribunal decision, the CAS decision before the Swiss Federal Tribunal, due to new evidence, because 1 year later she found out that there were new methods to diagnose her blood, because she alleged that her blood, the high level of the blood, red cell blood, were high because she's suffering of abnormality from her father, so hereditary abnormality. Swiss Federal Tribunal rejected her petition, and she went to the European Court for Human Rights, and the case is still pending there. And you have the reference case down there. 4 years, 5 years now, so we'll see when the European Court will decide or publish the decision. Of course, during all those years, she wasn't able to earn any money. She wasn't able to participate in competitions to win medals. So she claimed in front of a regional court in Munich some damages amounting almost 4 million euro. And the argument that she raised, again, CAS is not independent, is impartial due to the ICAS composition, that the ICAS is the one appointing all the arbitrators, that only 4 members are appointed by the athletes on the ICAS, and that CAS doesn't comply with due process, meaning that the agreement that she signed before the competition is invalid. The regional court in February 2014 rejected the appeal based on the res judicata principle, saying that she cannot review the case as the award case, CAS award, is final and binding, and the challenge of the jurisdiction of CAS should have been raised way before. However, in the grounds of the decision, the regional court underlined that the athletes, by signing, they had no choice to sign that agreement, because if you want to participate in a competition and win medals, you have to sign that agreement. If you don't sign it, then you can only train, and that's it. So in order to be able to participate in any competition organized by the International Skating Union, you had to sign that agreement, referring all the dispute to CAS. Another point underlined is the closed list of arbitrators. We have around 330 arbitrators on that list, and as I said previously, there is no recommendations from the athletes. Of course, not a lot of athletes' unions exist for the moment, but that's something maybe for the future, that athletes should be organized in unions in order to have more power, in order to contest the admission form to participate in competition. One thing which is quite interesting is that the CAS Secretary General, according to the CAS code, is entitled to make rectifications of pure form and may also draw the attention of the panel to fundamental issues of principle in their decision. So meaning before the signing of the CAS award by the President, you have to send the decision to the Secretary General of the CAS, and he might change the form or draw the attention to the panel in respect to obvious fundamental issues. I would like to talk a little bit of the ICAS composition. That's the supervising body of the CAS. It's composed of 20 members. 4 members, as I said, appointed by the International Sports Federations. 4 members appointed by the Association of National Olympic Committees. 4 members appointed by the IOC. And here it's quite interesting, 4 members appointed by the 12 members after appropriate consultation with a view to safeguarding the interest of the athletes. So only the 4 members here are representing the athletes. So 1 out of the 5, 1/5. What is the impact of the German High Court decision on sports arbitration? I don't think sports arbitration is called into question. Sport arbitration, as we know, is well recognized around the world. The AFC, for instance, we, in our statutes, refer to the CAS as an appeal court against our final decision. As my colleagues previously said, the arbitration procedure is quite quick, cheap, and flexible. You can ask, there's a provision in the CAS code according to which the parties can request an expedited procedure. In our case, we had in front of CAS here in Kuala Lumpur, the player was suspended for 8 matches. The AFC Champions League 2015 started already. We suspended him for the AFC Champions League, so he was quite in a hurry to hear the case, because 8 matches for the AFC Champions League is almost all the matches until the final. So we proposed, as good faith, the CAS to expedite the procedure in order to give the possibility to the player, in case he wins the case, to participate or to play in the AFC Champions League this year. Of course, we need arbitrators with the relevant skills. Reason why we have even a football list arbitrators it's published on the CAS homepage. We had in Sydney for the Asian Cup this year, we had an ad hoc panel of arbitrators in case we had an appeal during our competition. And now we have decentralized offices in New York, Sydney, and alternative venue for hearings like here in Kuala Lumpur. So all these shows that sport arbitration is in place, well recognized, and I don't think the Perstein or Miss Perstein would change the whole world of sports arbitration. However, CAS might reform some area of her institution. Already in '94, again German, went to the Swiss Federal Tribunal and contested one CAS award. And following that decision and following the view of the Swiss Federal Tribunal, CAS had to change its institution or composition, because previously IOC was the one financing CAS. Following that decision was the creation of the ICAS to have more independence, even though now we have, out of 20 members, we have only 4 members representing the interest of the athletes. Now we have 2 arbitration divisions and the creation of the CAS code in '94. Possible reform following the Perstein case, actually. In my opinion, maybe we should have all stakeholders represented on the ICAS, meaning the athletes, of course, but what about the referees? What about the clubs? What about the sponsors? Regarding the list of arbitrators, maybe to open the list of the arbitrators, of course, requiring several skills, minimum requirements, but to give the opportunity for parties to appoint an arbitrator who is not on the list. In panels composed of 3 arbitrators, usually the president of that panel is appointed by the president of the appeal provision, which is appointed by the ICAS. So as we said, only 4 members of ICAS are representing athletes, so there is a clear imbalance. In appointing that president of the panel, why not having an appointing committee composed of the president and 2 vice presidents, one representing the federation's interest and one representing the athletes' interest. Hearing to make public in case there is a public interest. Now usually the hearings are not public unless the party agrees. I've never participated in a public hearing yet, but if there is a public interest, why not open the door and show the sport community and the public how it works? And as Paul said this morning, publish every single CAS award, because there is some small family in the lawyers acting in front of CAS, and they have all the CAS awards, and you need to know them to get a CAS award that is not published. So now it's getting better, but it's still not transparent. So we really need to move forward and be able to get all the CAS award published, because now they publish some CAS award, but in the CAS award there is some reference to previous CAS awards, and those CAS awards are not published. So we need to have access of all CAS awards. And quite strangely, I would like to say that the Perstein case is quite interesting, because she's German, going in front of German court. We could say, would the German court protect her? She's famous in her country. She's successful, won a lot of Olympic medals. Why wouldn't we challenge the independence of that regional court and say, are you protecting your athlete? So, perfect world doesn't exist, I know, but I think for the moment, CAS is well established and will have more and more success in the future. The Persson case is still pending because the International Skating Union lodged an appeal in front of the Supreme Federal Court, as previously the higher court accepted to review the case. So now it's pending in front of the Federal Court, so everybody is expecting the decision of that court to see which reform, if any, shall be undertaken by CAS. Thank you.
Thank you, Benoit. With